Obviously, the justices have to interpret the words of the Constitution when they get a case. So let me ask, can you discuss the four common methods of interpretation of the Constitution? What are the advantages and disadvantages of each? And what is the importance of written opinions in all of this?
Among the methods adopted by the Supreme Court, probably most Americans are familiar with the court's struggle to understand the language or the wording in the textual provisions of the Constitution. So the first approach or method would be textualism. Americans are familiar with this most recently because Justice Antonin Scalia was a very prominent exponent of looking at the exact words of the Constitution in light of what the American people understood those words to mean when the Constitution was adopted. That was the view of Justice Scalia, who stood on the right of the court, and in an earlier era, Justice Hugo Black, who was a more liberal justice, took a similar approach, emphasizing or even exalting textualism. He was famous, for example, in saying of the First Amendment right of free speech that when the framers wrote those words, "Congress shall make no law," it meant no law. He was as close to an absolutist as we've ever seen in our history.
And I was going to interrupt. I will come back to the rest of the question, but I was going to ask how someone like Justice Scalia would interpret that very part of the First Amendment, which says there shall be no law abridging freedom of speech, and yet all of those justices and 99.9% of the American public will favor some laws that abridge freedom of speech. How would a textualist rationalize that?
They would certainly say, as in the case of Justice Scalia or in the cases of Justice Black, that there were certain areas of speech, for example, that were exempt from protection even at the founding period. In other words, taking the view that some areas like obscenity, for example, was never protected. Well, critics of that approach will say that's a self-serving way of reading the language, or critics would say that's why an embrace of textualism has such sharp limitations that it's not a particularly realistic approach or a mature approach to constitutional interpretation. And so the second method, which would embrace the concept of original intention jurisprudence, which emphasizes the idea that the legislative debates or the intentions or aims of the framers of the Constitution as expressed in the Constitutional Convention are entitled to great weight. So those who would advocate that historical approach would say it's not enough to look at textualism, let's see how the framers explained it. The reason for the emphasis on originalism, as it's called, would be seen in the difficulty sometimes of crafting an idea and effectuating its real meaning in language. It's often very difficult to do that. And on a doctrine centuries older than the Constitutional Convention, plumbing the depths of English law, English judges had often said, let's take a look at what Parliament intended to accomplish. And that was a doctrine that had great currency during the founding period. That's another approach or another method to interpreting the Constitution. Another method then would be to take account of fundamental principles such as republicanism or natural rights, and the structure of the Constitution as a means of trying to understand the Constitution.
What is the importance of written opinions?
That's a very, very important subject because the availability of a written opinion helps to produce stability in American law and predictability. Going as far back as the 14th century in England, when for the very first time opinions were not merely written, but in fact recorded or copied, and a few copies were located conveniently in the larger population areas, including London. That gave attorneys for the first time the opportunity to closely study the written opinions and to guide them in advising clients. It brought an element of predictability. And as opinions are written over the course of our history, then Americans and others who study the court decisions, governmental officers and others, have an opportunity to see not only how the court might have interpreted a provision of the Constitution in a much earlier time, but to see how the court has, in fact, evolved in its understanding of a textual provision or so.
So let me make sure I understand this. There are four common ways to interpret the Constitution: textualism, originalism, and the other two
would be looking at fundamental principles, the structure of the Constitution, such as the claim of natural rights or republicanism. And the fourth, often the subject of great discussion and debate in the nation's newspapers and in the nation's law schools, the concept of reading the Constitution in light of changing circumstances, viewing the Constitution as a living, breathing document. Now, these last two provisions can generate a great deal of controversy, but it's particularly the fourth one that has been the subject of great debate. When the justices read the Constitution, for example, in light of changing conditions or circumstances in the country, reflecting the fact that the nation is a far different country than it was in 1787, a number of questions arise. Do the justices interpret the Constitution in light of what they think is good for America? Do they interpret the Constitution in light of what they perceive the American public believes the Constitution ought to mean in the 21st century? So questions arise about that method. And then internally speaking, when you look at different provisions of the Constitution, how do you make a constitutional provision written in 1787 relevant to our times? How do you adapt the language or the terms used within any provision to a nation that's much different than it was when it was founded?
Can you discuss for a moment the advantages and disadvantages of each of the four methods of constitutional interpretation?
Let's take textualism first. There are advantages in the sense that the language represents to the American people what the framers were thinking when they wrote different provisions and clauses of the Constitution. But as James Madison himself wrote, it's very difficult to actually capture the precise words to convey the intentions or aims of the lawmaker. And so textualism, which has a rich history, nevertheless has many flaws in it. Many law students across the country, for example, will be taught about the famous Bolognian law in 13th century Italy, where the legislature prohibited, quote, the spilling of blood in the streets on the theme of preventing violence. Well, once upon a time, a man fell from a fit in the street. A nearby physician rushed to his aid. In order to save his life, had to engage in a little bit of an incision in his throat that caused blood to be spilled in the street, and that created an extreme problem for a textualist or a literalist. Do you punish and imprison the physician for saving the man's life when it caused blood to be spilled? The answer was certainly not, and that's what would lead people to go behind the scenes of the language and ask, what were the legislators or the lawmakers trying to accomplish? That introduces originalism. So the disadvantages are pretty clear. Literalism is self-defeating. On the second method of originalism, there's a lot to be said for that. Certainly, English judges followed originalism as far back as the 13th century as a means of better explaining the aims of the lawmakers. And the framers of the Constitution embraced originalism because, of course, they cut their teeth on English law and they understood the importance of trying to capture the real aim of those who wrote a statute or wrote a constitution. They were reminded by the learned Blackstone in England, and they were reminded by Chief Justice Marshall years later that the job or the function of the court is to, quote, say what the law is. So that leads to the question, how do you determine or ascertain what the meaning of the law is? It drives you back to the intentions or the aims of those who wrote the Constitution. But it has very severe limitations as well. The doctrine of originalism cannot thrive if the historical materials are inadequate. Thus, the eternal question, do the convention records capture the aims and the intentions of the framers? And I think the answer is in some areas, the aims or intentions of the framers are very, very clear. In other areas, they're a little bit more muddy. But the question that arises from that approach is to ask, should the nation be governed by the intentions of men in the 18th century who could not have anticipated a much different world. The third approach, that of trying to identify constitutional interpretation by exalting particular fundamental principles that lay behind the creation of the republic, including republicanism itself or the theory of natural rights, has a great appeal because people are looking to the structure, the very nature of the Constitution, the spirit of the Constitution, but the spirit is so ephemeral as to deny any very objective touchstones or standards that would allow justices to interpret the Constitution. And so if you raise, for example, natural rights as one of those touchstones, Americans applaud the concept of natural rights, but that's just a literary theory. And to allow judges or justices to interpret the Constitution in light of natural rights gives great room to the justice to move well beyond the legal issue and to invite the justice's own personal views. And then finally, the fourth issue, or the fourth approach to constitutional interpretation, in which the justices are trying to view the Constitution as a living, breathing document, one to be adapted to the needs of our time, has great appeal to the American people. First of all, because the Constitution should not be relegated to an 18th century in which no longer resembles the needs of America or the nature of the country. That's a strong appeal. Secondly, the idea that the country has changed so dramatically in its social relations, for example, not to mention technologically and culturally, suggests that the document should be updated by the court so that it does remain relevant to our time. But on the downside, critics can say that if in fact the justices are going to interpret the Constitution in light of what they perceive to be good for America in our time, the question arises, how do the justices know what's good for America? In addition, and here's the particular strong argument against that approach, is that it invites justices to impose their own views, their own preferences and predilections, which essentially is the concern against which advocates of judicial self-restraint are urging judges to restrain themselves. And that's an old concern going back to the founding of the Republic. As Alexander Hamilton asked, how do we protect against judges from following, quote, the trackless imaginations of their minds?